Ghislaine Maxwell, we've spoken a lot about Ghislaine on this channel, and she just got a bad ruling from the Second Circuit Court of Appeals. She's staying in custody. If anybody had any doubts about that, well, now you don't, because she's not going anywhere. We've long speculated that that was not going to happen. Her attorneys are really trying hard to get her out. They've submitted a number of different bail requests. Judges are denying all of them, and they took up one of the more recent denials to the Court of Appeals. Remember, she's being prosecuted out of a federal district court, and so when they originally denied her bail, she tried to go and appeal that so that she could get a different judge to let her out of custody. Well, of course, the judge didn't do that. We're going to go through the story, and I want to give you an update because remember, Maxwell has also been charged with a new violation. She had her arraignment on that, I think last week, and the arraignment is very, very basic. It's basically, hey, we've got new charges against you. We need to make sure you know about that. Do you know about it? Yes, we do. All right, well, nothing's going to change. We're not going to let you out of custody, so we're just going to add this charge to the other charges that you've already got, and we're going to see you at the next court date. So that's really all that was about. But there is a new interesting thing that happened. Ghislaine Maxwell was in custody, and she was meeting in person with her attorneys. Well, when she left that meeting with her lawyers, remember, in custody, she walked out with some papers that her attorneys had given her. According to the jail, that's a big no-no. Not allowed to do that. When she took those documents out, the jail confiscated those documents. Uh-oh. Did they just get her legally protected attorney-client privileged information? And if so, what does that mean for her case? Could be a big problem. A lot of letters, a lot of motions, a lot of issues have been flying back and forth over the last few days in the Ghislaine Maxwell case. And we're going to go through it because it's some pretty impressive lawyering. You know, some people are saying that her legal bill for her defense lawyers got to be in the 10, 20, maybe even $30 million range. They are earning it. They're doing a great job, and we want to show you how they are structuring and laying the framework for more appeals and a really solid defense for Ghislaine Maxwell. So let's go through this article over from the NY Post. You can see here, it says a trio of judges from the Federal Appeals Court in Manhattan denied Ghislaine Maxwell's request to be let out on bail while she's awaiting trial for allegedly procuring underage girls for Jeffrey Epstein. Three-panel judge from the Second Circuit Court handed down a one-page ruling on Tuesday. Today, I'm going to show you that here on the next slide, denying the bid and ordering Maxwell's attorneys to raise any issue they might have about her incarceration in a lower district court. So they're saying you can't get out of custody. And remember, one of the reasons that they wanted her to get out of custody is because they said that the conditions in the jail were so bad. She was losing her hair, couldn't sleep, being woken up. You know, it was the sewage was backing up, had no clean sanitation anywhere. So they were saying she has to be out because the conditions are just so unbearable. Well, the Court of Appeals, as we're going to see, said, well, take that up with the lower level court, district court. All we want to know, or all we're ruling on here, is whether we are going to let you out or not. And the answer is not. So Maxwell's attorney, David Marcus, said in an email that he was, quote, heartbroken by the decision. Says, we are considering our options for next steps. Marcus insisted Maxwell can't prepare for trial because she's awakened every 15 minutes in the night by jail guards who shine flashlights in her cell. In the hearing, Assistant U.S. Attorney Laura Pomerantz said the constant checks were routine in the lockup, a claim Marcus disputed. So there's nothing routine about it. The idea that she has an eye mask on is wrong. She either uses a sock or a towel to block out the light on her own. The appeals court said in the order on Tuesday that, well, she could raise those concerns with District Judge Allison Nathan, who is overseeing her case in the Manhattan Federal Court. The panel wrote, to the extent the appellate seeks relief specific to her sleeping conditions, take it up with the district court. Here is the opinion. You can see here, not much to it at all. United States Court of Appeals for the Second Circuit. You can see this was filed today, April 27th, 2021. Ghislaine Maxwell says here, appeals from the order of the district court denying bail upon due consideration. It is hereby ordered that the district court's orders are affirmed and the appellant court's motion for bail or temporary pretrial release is denied. See that right there? During oral argument, Maxwell expressed concern that she was being improperly deprived of sleep. To the extent that they seek specific relief to her sleeping conditions, take it up with the district court. Signed off on by Catherine O'Hagan Wolf, clerk of the court, signed off on, of course, by the Second Circuit. And so, I don't think this was a big surprise to anybody, right? I've been sort of saying here that I think it's legally unequal that Ghislaine Maxwell is not being left out of custody. There are a lot of other individuals who have committed more heinous crimes than Ghislaine Maxwell who are out on bail, right? For example, you can pick Derek Chauvin, right? He murdered somebody legally now, according to the court of law. He's been convicted of that, and he was out on bail for months. Rittenhouse, same thing. And a lot of the others that we've talked about, right? You can actually kill somebody and be out on bail. But what's different about Ghislaine Maxwell's case is the flight risk component. She had dual citizenship, I think, in France and even maybe in Britain. And many people are saying that she's got unlimited assets, right? She sort of disclosed a lot of this stuff to federal authorities, but is that accurate? If she is out, are we ever going to see her again? Probably not. So I think it is, in fact, the right move that the court is not letting her out. Legally, it may be, it's one of those margin cases where most people in her situation, yeah, they're going to let him out. She's not most people. She was the number 2 to Jeffrey Epstein. Epstein's not around anymore. So the court is doing everything in its power to keep her in custody. We're going to see if any of that changes given what just happened recently. Maxwell has requested bail 3 times since she was arrested. She's been rejected each time. In letters to Nathan, her attorneys detailed harsh conditions at the jail, including the constant checks in the middle of the night, which they say are done by guards because the Bureau of Prisons failed to stop Epstein from killing himself in 2019. Allegedly. They also argued she's dropped weight, lost hair, was abused by a guard during a pat-down. Maxwell is accused of grooming underage girls for Epstein to abuse in 1990s and early 2000s. 8-count indictment filed in Manhattan federal court. The indictment includes 2 counts of perjury that will be tried separately from the sexual misconduct charges. She's pleaded not guilty to all charges. Trial has been tentatively set for July, which we'll see about that. I'm not holding my breath that we're going to have a Ghislaine Maxwell trial in July. If anything, I think it's probably not even going to happen this year, if I had to take a guess. But I could be wrong. I hope I am, because I do want to see what happens here. We've got Ghislaine Maxwell, another story, says that she uses a sock to cover eyes from the jail guards' flashlights. So every 15 minutes they come, they poke in. She's saying that she cannot prepare for her trial due to that. Prosecutors say those are just routine, but this is the real big story that I wanted to mention. I think very interesting here. The jail guard, this is another story over from New York Post, says that a jail guard stood knee to knee with Ghislaine Maxwell as she used the commode, which is the toilet for those of you here in America. A jail guard stood knee to knee with Ghislaine Maxwell as she used the bathroom in Brooklyn lockup in an attempt to intimidate and humiliate the accused madam, said her lawyer in court papers filed Monday night, last night. The guard, team leader at the Metropolitan Detention Center, suspected Maxwell of improperly taking legal papers from her attorney, Bobby Sternheim. All right, so pay attention to this name. We're going to go through a letter from Bobby Sternheim after the pair met to discuss her case on Saturday, according to the filing. A group of guards confiscated Maxwell's legal documents, and threatened her with punishment for allegedly taking non-approved papers from her attorneys, her lawyer alleged. So Maxwell was then given permission to use the bathroom, where a guard allegedly decided to intimidate her further. Unlike any other occasion, the guard team leader stood knee to knee with Maxwell while she sat on the commode in a small area containing 1 toilet and a sink, said Sternheim in a letter to the judge. Having a guard standing over her while she used the commode caused her to feel intimidated and humiliated. So that's a whole separate issue, right? A guard standing over you while you're using the restroom. It is humiliating and it is intimidating, and I think that would be the case for anybody. But I'm not even interested in that per se. I am way more interested in this idea that the jail took her legal documents away from her. Maxwell was meeting with her attorney, Bobby Sternheim. Documents are exchanged hands. They take them away from her? Whoa. So let's take a look at this letter that was filed in court yesterday, today, the 27th, it looks like. So you can see here, Bobby Sternheim, okay, as soon as this happened, fires a letter out. This is some excellent legal work I want to show you. Dear Judge Nathan, I write to report an incident stemming from an attorney-client conference with Ghislaine Maxwell. Guards on Maxwell's security detail wrongfully seized and reviewed her confidential legal documents and then intimidated her by standing over her in the bathroom. The incident has compromised her ability to prepare for trial, to confer with counsel, and to retain confidential legal documents. In addition, intimidation and humiliation has further exacerbated her feelings of insecurity due to the power exerted upon her by the guards. On Saturday, Leah Safian, another lawyer, and I attended a pre-scheduled in-person legal conference with Ms. Maxwell. The entire 2.5-hour conference was conducted under the constant watch of 4 to 5 guards, including a lieutenant with a camera on a tripod focused on Ms. Maxwell and with counsel while recording audio and video and captured on surveillance cameras affixed in the room. After counsel left the facility, Ms. Maxwell called me to report that her legal papers were confiscated. This is a big deal, right? If you're an attorney, you have something that's very sacred. It's called attorney-client privilege. All of the conversations, the communications that you have between you, the attorney, and your client, it's so sacred. I mean, you basically die for that. You'll die to protect that. And if the opposing party, the police, the jail, the prosecutors, even the judges, if they get your work product, if they get the secret information that you're communicating about back and forth, that is a breach that is catastrophic, in my opinion. Now, judges and prosecutors, they typically look at it differently, but this is something that is sacred. It needs to be protected. It's your right to counsel. It's something that's enshrined in our Constitution. You have a right to that counsel, and it's a right to a meaningful relationship, right? You don't just get token counsel. Yeah. Oh yeah, you get a lawyer, right? Good for you. Good luck, right? He really works for us, and he's not going to do anything for you because he's part of our government. He's on our payroll, right? You want a legitimate protections for that sacred relationship between defense and your client. Here, that was breached, is what it sounds like. Those were confiscated. Later that day, I received an email from MDC Legal Counsel. So the jail's lawyer sent an email over to Ghislaine Maxwell's lawyer. So once again, let's frame this back out. Maxwell's in custody. They're not going to let her out. Her attorney, Bobby Sternheim, and another lawyer come in and meet with Ghislaine. They're sitting there in custody in a federal detention center, MDC Metro Detention Center, whatever it is, and they're having a conversation. Attorneys leave. They leave documents with Miss Maxwell. Jail guard comes in, says, oh, no, you can't have those. That is in violation of protocol. They take those documents away from Maxwell. Attorneys are now home. The jail lawyer emails Maxwell's lawyer and says, hey, just got to let you know, it's been brought to my attention by the staff in Brooklyn that Miss Maxwell received paperwork that was not in her possession upon entering the legal visiting area. As you are aware, the policies set forth for Brooklyn legal visits do not allow for the passing of any materials during a legal visit. Due to our policy and procedures, the additional documents that were provided to Miss Maxwell were confiscated. Those materials were put in an envelope and will be returned to you tomorrow upon your arrival at the institution. Please note, you may put these documents in the legal mailbox in the lobby of the East Building. So that lawyer for the jail's, okay, I'm just going to send this email off. Hey, you're in violation of our protocols. We're going to just collect those documents, not going to look at them. We're going to put them in an envelope. You can get them tomorrow. Should be the end of it, right? Oh, okay. Oh, sorry about that. Didn't know about your policies. Didn't know about your procedures. Our mistake. We'll get it tomorrow. Do you think that's what happened? No. Here's the letter that Bobby Sternheim fired right back. Says, I emailed the following in response. Your accusation is inaccurate, as is the information reported to you by your staff. Nothing in Ms. Maxwell's legal papers was given to her by me or by Leah Safian. Both Ms. Safian and I dispute these allegations in the strongest terms. You see what they're saying? You're accusing us of violating jail protocols. Everything has been video recorded, as we saw, right? She said that there are 4 cops there, 4 detention guards there. You're accusing us of bringing in illegal documents and leaving it here. We're not going to let that stand. So they say, both Ms. Safian and I dispute these allegations in the strongest terms. Today, Ms. Safian and I met with Maxwell for a scheduled legal visit under the gaze of 5 guards and a portable camera recording audio and video. After the visit concluded, we left the visiting area. Guards accused Ms. Maxwell of possessing documents obtained from counsel. The guards seized confidential documents from her, including documents she had previously received in legal mail delivered to the MDC and given to her by MDC staff. After seizing highly confidential documents, subject to a protective order that your staff is not authorized to review, and work product, the guards began reading the documents and have not returned them to Ms. Maxwell. At no time did the guards who were assiduously watching and filming the legal conference bring any concern to my attention, so it is quite telling that you have been contacted when counsel are told that legal staff are unavailable during the weekend. No documents were given to Ms. Maxwell for her retention. Demand is hereby made for an immediate identification of the documents you claim were not in Ms. Maxwell's possession upon entering the legal visiting area in advance of the arrival of counsel, a list of guards present during the visit, and a copy of the video recording. Please immediately return the confiscated legal documents to Ms. Maxwell. They are her documents, not mine. The confiscation of these documents has, there it is, deprived Ms. Maxwell of her time and seriously impaired her ability to review legal documents and prepare for an upcoming trial, adding to an already difficult situation. This matter is being reported to the court, and legal action will be initiated. Oh, it's beautiful. Oh, it hurts. It stings. If you're that government lawyer on the other end of that, you're going, oh no, what did I do? Because now they got to respond to this. And it's not just this, right? Let's take a quick look and see what else is going on. In advance, guards have gone through her legal papers. In a break from such protocol, the guards did not do so prior to commencement of the legal visit on Saturday. After the legal conference and departure of counsel, the guards seized all of her paperwork. So this is all back to the court now. So what you see here in this document, this is being drafted to the court. Okay, so this they're telling the judge, hey, look, this is what's going on. Then this is the actual email that was exchanged. Now they're communicating back to the judge. Hey, judge, look, also, in advance of previous in-person legal visits, guards have also gone through her legal papers. In a break from protocol, they also did not do so prior to commencement of the legal visit. They didn't check her documents before she went into the room. They didn't do so prior to that day. And so they're making all of these accusations. You can see that this goes on. She no longer feels that her legal papers are safe. She believes that the confidentiality required to prepare her defense for trial has been irreparably breached. You know what this is laying the framework for? They're going to ask to get her out again because they screwed it up, because law enforcement, the prison guards here, breached that sacred bond between an attorney and their client. And now irreparably breached, has no trust, has no faith in the confidentiality of her defense. And now they're going to be renewing another claim. And this is another stake in the ground that they're going to come back to if she is convicted of something. They're going to say, look, well, of course she was convicted. She couldn't defend herself. She had the friggin' government reading her legal documents that were confidential and sacred between her attorney and herself. It's good stuff. Now, it's not just a nasty email. Okay. Do you think that her attorneys are going to just stop there? No, not at all. They want everything now. Yeah, you just accused them of breaking protocols. You think it's going to stop there? No, it's not. So what else are her attorneys asking for? Ms. Maxwell requests the court enter an order directing the MDC through its legal counsel to provide Ms. Maxwell's attorneys only the following information: the identity of the persons who seized the legal material, the inventory of the items seized, a statement subject to penalty of perjury regarding whether the materials were duplicated in any fashion, whether any disciplinary or corrective action was taken against any of the offending guards. So now they're out for blood, right? You screwed that up for our clients. It's not going to happen again. We want blood. We want the person who actually seized those documents. And then we're not done yet, because they're going to send a direct letter now over to the jail itself. You can see here's another letter, Law Offices of Bobby Sternheim, April 26, a notice and a demand to preserve items of evidence. This has nothing to do really with Ghislaine's underlying case, right? Ghislaine's case is about sex trafficking in the 90s and the 2000s with Jeffrey Epstein. Now they want evidence about this interaction. They're sending a demand letter about this little hubbub that happened on Saturday. It says, as counsel for Ghislaine Maxwell, I'm notifying you as legal counsel of the obligation to preserve documents. What do they want? As stated on the April 24th email, all images, video recordings, data files, everything, anything that was captured on surveillance footage. I want names of all guards, including the lieutenant and anybody who is present in the visiting room. Any written or recorded communications, whether stored in electronic, digital, or paper format, obtained in connection. A list of documents that was claimed to be in Maxwell's possession at the time. A list of all documents that were claimed to have been given to Miss Maxwell by counsel for her retention during legal conference. Any written correspondence, blah, blah, blah. Please take adequate steps to preserve all documents, all data compilations, including all electronically stored information. Counsel for Maxwell is going to be seeking electronic data in the custody and control of individuals. And it goes on and on. Please take all necessary steps to prevent the deletion and the destruction of any of this information. Yours truly, Bobby Sternheim. Wow. Right? Opened up a whole can of worms there if you are a person who is a member of that opposing party. If you just received that letter, not particularly good. And so, my friends, that's it for the show today. For some reason, our PowerPoint slides were not syncing, so I don't have any questions queued up. Miss Faith and I are going to figure that out tomorrow, but that's all right because I got to get out of here. I have a 5:30 sharp meeting, and so we're going to button it up right there. As is usually the case, I want to thank all of you who support the show over on Locals. Typically, at the end of the show, we sort of have a little thing that we go through to thank all of our newcomers and anybody who participated and asked questions today. We're going to get back on track with that tomorrow because I got a jet, and I want to just thank you for being a part of the program. Thank you so much for all of your continued support. We're going to be back here, same time, same place tomorrow at 4 p.m. Arizona time, 5 p.m. Mountain, 6 p.m. Central, 7 p.m. out on the East Coast. And for that one Florida man, everybody have a tremendous night. Eat well, sleep well. I'll see you right back here tomorrow. Bye-bye.